Hi there, everybody. Good day. Sorry we're starting a little late. We had some issues with the technical our network, but we're fine and we're here online. So I hope you'll all still be there. I hope we'll still maybe if you'll come back if you were there previously and we hadn't set up, you'll come back. Well, today the questions we had collected some questions to answer. However, something that's new as from yesterday, the USCIS announced new fees. These fees will take effect as from April 1st, 2024. So that means we have in 8 weeks' time we will start paying new filing fees. So we have February, we have March to use the old filing fees. Come April 1st, we're going to start paying new filing fees. And the changed filing fees are increased. We're going to start paying more for each application. And I wanted to give you a basic breakdown of what's happening. As you come into the office and we start working on your cases, you will now know the exact fees for each application. And we're also going to put out on the website and on our social media pages the new filing fees, the precise amount. However, the most important things to know about the increased filing fees are these: they're a little graded, and we're seeing that immigration, I think, is trying to drive people. The USCIS is trying to drive people towards online filings, so that you can go into their portal, their website, create a portal for yourself, and file your application online. They want people to do that more. So the filing fees for online applications are reduced. They are you if you choose to file online, you will pay less than if you choose to file a paper application. Also, something else that is new in the increased regime, well, it's not so new. If you were practicing immigration law many years ago, you would know that there was a time when we paid for all the ancillary applications, the EAD application, the advanced parole application. It's back. So now, not only is the actual green card application, the I-485, increase have a filing in newer increased filing fees, you also have to now pay for your employment authorization application and your advanced parole application, so that ability to work while your green card application is pending, it's now something you're going to have to pay for. So shortly, like I said, if you call the office when you do come in, we'll tell you what are the new fees. And starting from April 1st, you have to pay the higher fees if you're filing. That's from April 1st. And then in the naturalization application, they are going to work hard better at helping people who whose income meets a certain low threshold, so that if you don't make up to a certain amount of money, you're a green card holder, but you want to apply to naturalize, you can ask for lower filing fees. On the business side, there's also been increases. However, what they did this time is to do something that will not make it very difficult for small businesses. Because you remember, they say the small businesses what's the backbone of business in America. Most businesses are small businesses. So if you are classified as a small business or a nonprofit business organization, you're going to get to pay lower filing fees than a big business. And that's on the business immigration fee, on the business immigration side. Also, for the H visa, those on in the all the entire H category, there are going to be each application is going to have its own particular filing fee. This is different from what we had in the past, where everybody paid all companies paid the same amount for the same fees. I'm sorry, for the same form. So if you're filing an H visa, if you're filing an L visa, it was all the same application fee. However, now it's going to be different. In the H category, each category is going to pay a particular fee. And in addition to that, well, they will distinguish between the bigger businesses and small businesses and non-profit organizations, so that those ones, the small businesses and the non-profits, will pay lower filing fees. And like I said, the new fees take effect as from April 1st, 2024. So today is the 2nd of February. We have all of February and all of March to start filing if you want to use the old filing fees. If when let's say the USCIS receives your application on April 2nd, they're going to look at the postmark. If the postmark, that's the mark put by the post office, is for, let's say, March 31st, you're fine. You get to use the old filing fee. But if your letter is postmarked April 1st, you're going to use the new filing fee. So what the takeaway from there is this: if you want to file now, if you're ready to go ahead with the application, now is the time to send it out, so that you don't have to use the new and increased filing fees. And it's going to affect people a lot, because now we're looking at increased I-485 green card filing fees. We are looking at increased relative petition fees. We are also going to be looking at having to pay for your employment authorization and having to pay for your advanced parole applications. That's going to come up to quite a pretty penny. In the end, you're going to possibly see up to $2,000 to $2,500, up to $2,000 worth of filing fees, and that's a difference from what we have now. We're paying now a total of $1,760 for your filing fees. So it's just to let you all know, and we get ready and see if we can assist you, those who are ready, of course, to get their applications out the door before the new fees come into effect. The next thing, let me see if I think there might could be a question coming in already. Okay, let's see. Oh no, that person has the person has moved back a bit. So we'll just continue. So, being that I heard, when I found out about this fee increase yesterday, I thought, well, if the things I'm going to talk about today, I prepared myself to talk about, it will change a little, not so much maybe into the particular immigration law things, but just the whole process. For instance, managing your expectations when you're dealing with immigration, dealing with your lawyer, dealing with USCIS, and managing your expectations at the same time. The thing to know about it is this: it's not up to your lawyer to grant your application. Really, if it was up to your lawyer, they'd probably give you the grant application you're filing, but it's not up to them. Your lawyer tells a story. Your lawyer tells your story. It's based on the story you tell the lawyer that the lawyer puts in appropriate form and presents to immigration. And immigration considers your case and then decides to grant your case. Your lawyer's experience, knowledge, that will all guide how your case is prepared. So that's what you're paying for: their knowledge, which they have, and of course their experience is a multiplier. That's what I tell my clients as well. And another thing is regarding controlling the timing of the filings. How fast is immigration processing? Ever so often, we're going to, the case is filed and we have clients calling, well, it's been pending for a long time. That is really not something your lawyer controls. What your lawyer controls is the preparation time. And really, it's you that control it. So let's say you get your case, you and your lawyer start working on your case. Preparing, getting the documents together, that's something we, as in your lawyer and yourself, control. Once we send it to immigration, it's immigration that controls. And it can vary. Processing times vary. And there's really, every year, there just seems to be more cases being filed. So immigration is swamped down. Government policies will also affect how fast cases are being processed. And it may take a long time, it may take a longer time. And we see that that affects processing times. There are one or two mechanisms for inquiring, finding out about your case, if your case status, to see if there's anything holding it up and if they could just move it up. But in the end, it's all up to immigration. It's not something your lawyer controls. The filing fees is also something that's up to immigration. And of course, there's a difference between filing fees and legal fees, which you pay to your lawyer. You pay filing fees to immigration, you pay your legal fees to your lawyer who assists you. Every lawyer has her own or his own fee ranges. Some may be really expensive, some may be low, not so expensive, but all again, how expensive is in the eye of the beholder. The thing about it, though, is it's not so much what the lawyer is charging you as what value will this thing, the process, a successful conclusion of the process, bring into your life. So that's what I think is the way to look at this matter of filing fees, and then manage your expectations. A lot of lawyers will work with you, but again, it's all based on perception. Working with you, do you feel you're being worked with, or are you really being worked with? So that's it. Then, of course, going with you to your interview, a lot of lawyers will go with you. It's part of the process, part of the service when you sign up. You may find those who class going with you to your interview as a discreet, whole different process. And it's all going to depend on how the lawyer chooses to practice. But they will go with you. Once your lawyer goes with you, I think you get better respect from immigration, from USCIS. And um, certainly they're there to help make sure there's no overstepping of bounds. They'll help you. And people find they are nervous when they go to their interviews. And if your lawyer sitting there, well, they're just sitting, they can sit down there handing the officer your supporting documents when you go to the interview. So that should help you ease things along. Another thing again is then after the interview, what happens? Well, your lawyer is still involved. And when you get your results, let's say it's an approval, because that's what we're all aiming for, they'll tell you, your lawyer will explain to you what happens next. Because a lot of the times, after you've received your approval, it's just not a merry skip home. You may have other things. For instance, if you are somebody who's just got a green card, there's still other things in front of you. And if you have a lawyer, they will explain to you the timings for anything coming forward. Maybe you're going to need to remove condition on petition on your green card. Your lawyer will advise you, give you all the advice for that time. And then if you're someone who needs to naturalize, your lawyer will tell you, hey, this is when you should be able to naturalize. In a naturalization case, your lawyer will tell you the things you can now do after you've naturalized. You can take part in selecting the leaders of the country. You can petition for relatives of all manners. So that's what your lawyer does for you. And I hope just having knowledge of that helps you to better manage your expectations going into your immigration process. Oh, we're getting another a question that's asking about what whether somebody can petition for their cousins and nephews. No, you cannot. If you remember in one of the other videos we did, I explained that permanent residents can petition for their children and their spouses. US citizens can petition for their spouses, for their parents, for their children. Anybody who is not related to you in those degrees, you can petition for. So no, you cannot petition for your grandparents. You cannot petition for your grandkids. You cannot petition for your cousin or your nephew or your auntie or your uncle. I'm sorry. However, although I've said that, there's a little nuance to it again, of course, as in all things immigration law. The nuance to it is that in certain situations, you may find out that one has ended up obtaining immigration benefits from a relative. For instance, if you get adopted, that auntie can petition for you, or you can petition for that auntie. See how it works. How it works is this. Let's say your auntie adopts you. Your auntie who has adopted you may be able to petition for you, and you may get a green card through your auntie. However, although you're looking at it as my auntie, but for that thing to happen, your auntie has to assume a parental relationship before you can get an immigration benefit from them. So if your auntie legally adopts you, then she can petition for you as her child. And this adoption this adoption petitions are only allowed where those relations are US citizens. So your auntie who is a US citizen can adopt you, but your auntie who is and petition for you, but your auntie who is a permanent resident holder, a permanent resident, that's a green card holder, cannot, doesn't have that privilege yet until you becomes a US citizen. So this is one of those situations that is nuanced, but just know that going in, only those first degree relations can be petitioned for. There's also a situation where you can get US citizenship to your parents, your grandparents. It's not because they're really petitioning, but that under the citizenship laws, it is possible in certain cases that you can acquire US citizenship, or you are deemed to have acquired US citizenship through your grandparents. Roughly speaking, let's say your parent was born in the US, left the US, and went to live outside the US between a certain age. If your grandparents who were born in the US are still alive, they may be able to, you may be able to acquire citizenship through them. So it again, like I always say, it's a little nuanced. If you call the office, you see the number, you call the office, schedule that appointment, we'll be able to go in depth with you and tell you whether you're able to benefit from one of those things. But just the shortest answer to that question is no. Only only certain relationships can acquire petition for their relations, but not you can't petition or be petitioned for by your aunt, uncle, grandparents. No. So that's it. There's another question coming in. Okay, it's the one about the person who petitioned, who helped them prepare their forms. The person says they wanted their form preparer wouldn't go to the interview with them. The thing about it again is this: there's people who may prepare forms for you, fill out your immigration forms for you, and then there's lawyers too who can help you with the immigration process. The difference is that your immigration lawyer is trained as a lawyer. He or she has a JD degree and practices immigration and a law license issued by, well, any of the states of the jurisdiction, or any jurisdiction in the United States, and the practice in the area of immigration law, same as they could have been practicing in the area of personal injury, medical malpractice, bankruptcy law. they have just decided to practice in that area of immigration law. Your form preparer, a notarial maybe, they are people who can look at a form, well, fill it out. And really, anybody can look at a form and fill it out. But I always explain to people, behind every immigration form is, first of all, the Constitution of the United States, which authorizes which authorizes the laws, Congress to make laws for immigration. Then there are the laws made by US Congress to govern immigration law. And then there's the regulations by the agencies, the executive agencies that put into a practice and effect, carry out the immigration laws. And then there's the decisions by immigration courts, which are agencies under the executive, and then but which get appealed to the federal courts in the judiciary system of the United States. So the cases from those ones also interpret the US immigration laws. It gets very complicated. And indeed, they say that the Immigration and Nationality Act is second only to the IRS code in its complexity. And it changes. Immigration laws and regulations, they change quite often. So just being able to fill out a form doesn't guarantee you much. You can fill out a form, fill out a form really good. You provide the name of your father, you provide the name of your spouse, all your children, when you got married, provide all the evidence. And it turns out, well, hey, you weren't even meant to file at that particular time. If you do that, you could run into complications. So I would always say, talk to an immigration lawyer and have them assist you prepare your forms and file your forms so that you can be better assured of being successful. It's not just a question of forms. There's a lot more going on than forms. And then, of course, there's a question I also received about documents. Well, they're asking for a particular document, and well, the person who sent the question says that they don't have the document anymore. Well, the way it works is this: when your immigration process needs a particular document, because you see, also, let me say this, behind it's not just filling out a form. Whenever filling out a form is like saying something to the US government, well, you have to support what you've said. So that's how come we have those supporting documentations. For instance, if you say, I'm petitioning for this person to be I'm a US citizen petitioning for this person as my spouse, you have to show them first, you're the US government, that you're a US citizen. You have to show a birth certificate or maybe a naturalization certificate. So every application is accompanied by supporting documentation, evidence, really. So the things to know is that if you have it, you submit it. If you don't have it, the particular one being asked, you could try and substitute it. Lawyers always know how to tell you which documents could be substituted for the best evidence document. Also, that brings us to something I think all immigrants need to know. Keep your documents safe. Keep your old passports safe because you need them. For instance, when you want to naturalize, they're going to ask you one day, well, all the trips you've made outside the US since you got your green card, how did you go to? How long did the trips last? You'll need to, and your passport, your old passports, that's the best way to say that, to provide that information. Also, for instance, when you're coming into you've come into the US and you're looking to apply for a green card, they want to know that you made a legal entry into the US. And a lot of the times you'll find that the immigration officer may have put a stamp in your passport allowing you in. It will tell you the day you came in and maybe how long you're allowed to stay, as well as on what class of non-immigrants you were let into the US. So that being the case, it's important to save all your documents. And then a very important one if you bring in documents from outside the US, which you want to use as supporting documentation, please make sure you collected the appropriate document from your country. Let me give you an instance. If you get your divorce decree, let's say you want to present a divorce decree, you can provide a divorce decree from any of the states in the US. You just go to the court and you get you a certified copy. Those are easily verifiable. But if you're bringing something from out a country not the US, make sure it's the genuine document. Because I've had people come into the office and all of a sudden, their green card application that was going fine is no longer going fine because they're being told that their divorce decree from the old country, from their home country, is not valid. And they're saying, well, but a lawyer gave it to me. That's what my lawyer gave me. The USCIS, if you remember in one of my videos, I told you the USCIS will always verify. They go to the court registry where you said you got your divorce decree from, and they will check to find out if that decree was issued by the court. In some countries, divorce is not just a simple, straight one-time process. It may end up, it may be a two-step process. I know those countries, some of those common law countries, you have to have a decree nisi issued first, then a decree absolute after a certain number of days. If you bring only the decree nisi, you'll be told that that's the termination of your marriage. If you bring a decree absolute, that is the end of your marriage. Correct. The certification that the decree nisi was eventually converted or made absolute. That's when what immigration will use as the end of your marriage, your old marriage. So those things are important to know. Whatever documents you're getting, make sure it's genuinely from the court because they're going to go back and check. And they know what documents the USCIS knows it, through the Department of State. The Department of State knows what documents are available in each country. Okay, so some countries don't have birth certificates for people of a certain age just because births weren't being registered at that time. So you have to go to their population commission or agency and get a letter. They know there's documents that they will accept. Lawyers know what documents because they bother to check. A form preparer doesn't. So the end of this thing is please make sure that the documents you submit are obtained from the proper places. So these are the things we're going to be able to deal with today. There's another question. Well, we're trying not to keep this thing too long, going too long. And okay, I can take another question. Hold on, and I will get to that question. Let me look. Okay, where is that question? Hold on, hold on. Well, there's a question from somebody who's asking that their U.S. citizen spouse does not work. Can that U.S. citizen spouse petition for them still? The answer is yes. Although she does not work, there's it's a fundamental human right here. It's a basic right here. It's one of those rights to privacy. You can marry whoever you want. Not working though, although you don't work, you're still allowed to marry. What will happen that when it's time for your affidavit of support in the adjustment process, clearly you're not going to make enough income to support your spouse. So you're going to have somebody else who does make enough income to come in and support you as a sponsor in the affidavit of support for your spouse. So your spouse, although they do not work, they can sponsor you. On the other hand, though, when you present with a spouse who doesn't work, it may be a fraud marker, and it may make immigration look a little deeper into your case and to see why somebody is marrying somebody who's not working. But if it's a genuine marriage, which is the standard, you'll be okay so long as you have somebody who can join your spouse as a co-sponsor in the affidavit of support. So that is what we're going. That's it for today. We don't want to keep it too long, and we'll see you next week, depending on next Friday, same time. But depending on the volume of questions we get following up, because this is going to remain online for a few days. So if you've watched this, you have any questions, you're watching offline, if you have any questions, type it in or call up the office. We'll take your questions so that next week, next time we'll show back up for the on our session online live, we can answer those questions. And if we get a lot of questions, maybe we'll even do a second one next week, a second live session next week. So I hope you all are keeping safe, keeping warm, and we'll see you again soon. Bye.